So we are bang on good afternoon, I think, and it's great to see so many people joining. The numbers are still climbing. We've had 115 people registering to join, but just conscious of people's time, and we've said that we'll run just for an hour today. So we're going to get going straight away. It's so fantastic to see so many of you. We are recording the session, and the slides that Chris is going to use throughout this next hour will be available to people after the session, along with the recording. It's great to welcome Chris. So Chris is a senior consultant that works with Nacro's Criminal Record Support Service and has over 15 years criminal justice experience. Chris is also a non-practicing solicitor with a criminal law background and delivers advice, guidance and training on safe and fair recruitment practices and criminal records disclosure to a variety of organisations. And I know over the last couple of weeks and months, there have been lots of discussion threads on JISCmail around managing safer recruitment of learners and disclosure of criminal records. So it's absolutely fantastic, Chris, to have you joining us today. I'm going to hand straight over. What I would say, it would be great if you could use the Q&A function that you can see. If you've got any questions for Chris, Chris is going to allow around 15 minutes towards the end of the session to take some questions. I'm sure there will be far more questions than we're going to have time to answer. So Chris has kindly agreed to go through those questions afterwards, and we'll provide a narrative and a bit of a crib sheet to people so that any questions that we don't get to as part of this session will get an answer from Chris, and we'll share that on the members network. Please use the chat to say hello and let us know where you're from. But if you can please make sure that your questions go in the Q&A, it's just much easier for us to try and follow rather than sifting through the chat. So Chris, without further ado, thanks so much for joining us today. Welcome to this NAMS webinar, and over to you.
Thank you, Joe, and thank you for inviting me along, and good afternoon to everybody that's attended. So today we're going to be talking about understanding criminal records and risk assessment. It is kind of like a high-level overview of what is quite a complex area. So obviously, please feel free to fire questions through, and I will all be happy to answer those questions when we come up to the Q&A part in approximately 45 minutes. So let's get into it. So when we talk about criminal records, we're looking at around 11.7 million people in the UK with a criminal record. So when we look at the population of this country, which is approaching 70 million, we're looking at 1 in 4 of the working population. So no doubt you will have students applying for courses at your institutions with criminal records, and it's probably more common than most people realise, just because of the number of people with a criminal record. And when we talk about a criminal record, we're talking about people who have received either a police caution or they've been convicted of a criminal offence. So when we talk about convictions, there's approximately 1.5 million convictions each and every year. And 50% of those, believe it or not, are for motoring offences. So that's about 750,000. Also, about 78% of the 1.5 million convictions result in a fine, which is quite one of the lowest disposals available to the court. And only 6.5% of convictions result in a prison sentence. So I suppose what that highlights is that when we talk about criminal record disclosure, when we talk about risk assessment, most of the information you will be receiving will probably relate to minor offending. It might be that you have students who have a recidivist background, i.e. that they might have a number of convictions, but they tend to be in the middle or towards the lower end of severity in most cases. And it will only be occasionally, given these figures, that you will come across some of the more serious types of offences that you will have to deal with. And when we talk about criminal record disclosure, I'm just going to do a bit of a whistle-stop tour through some of the legislation that affects this criminal record disclosure. We're going all the way back to 1974 with the Rehabilitation of Offenders Act, which is basically a piece of legislation that is saying after a certain period of time that a person must be treated as though they never received a caution or was never convicted. And that has an impact in terms of what you can do with data as colleges and universities, because it restricts what the information, the length of time the information is available, and what you shouldn't be doing once that time period has passed. So it works both ways. It protects the individual after a certain period of time. It recognises that, you know, organisations have to take information into account for various purposes, including safeguarding, which is probably the most prominent reason. But that should only be the case for a certain period of time, and then after that, the person should then be given the opportunity to move on past their past offending history. And then we go to 1975, and we've got the Rehabilitation of Offenders Exceptions Order, and that's the government basically recognising, well, there are some circumstances where we feel this information should be taken into account for a longer period, and that would cover, in your case, those courses involving placements in sensitive roles or sensitive environments, you know, your health, your social care, your education type courses, where you're entitled to do DBS checks. What type of DBS certificates are available? Set out in the Police Act 1997. And when we talk about vulnerable groups and we talk about work with adults and work with children, we can find the definition both in the Police Act 1997 and the Safeguarding Vulnerable Groups Act 2006. The definition was kind of stripped back a little bit in 2012 under the Protection of Freedoms Act. And then we get to 2018, when those of you involved who had the unfortunate having to deal with GDPR and data protection when those updates came in 2018. Basically, that's just saying, be careful in terms of the type of information that you request from applicants, and also be careful in terms of the level of check that you do, make sure that it's appropriate, because if you gather too much data, then you are in breach of GDPR data protection, in particular, not just in relation to the gathering of that data, but the processing of that as well. And then in 2020, we had some further changes to disclosure legislation, which relates to a rule called filtering, which we will cover. So there are two schemes of disclosure available to you. The first scheme is self-disclosure, and that's where you ask the applicant to disclose information to you, and they are obliged to answer that question depending on the course they are applying for. And then the second scheme is your ability to verify the information you've received. In your case, that would be through DBS checks, and we'll get into that later on. So I've already kind of covered the Rehabilitation of Offenders Act, but in essence, it underpins the system of criminal record disclosure in England and Wales. It determines when findings or admissions of guilt become spent. It will apply to all courses unless you can demonstrate that there is a legal exemption because of the nature of the course. So the exceptions order I mentioned previously applies. And if you want to know what those periods are in terms of when information becomes spent, then you can take a look at our website where there is a table. So I've provided a link there. For those of you that get the slides afterwards, you can just click on that link that will take you through to the different types of sentences and disposals, and will tell you how long it takes for each of those to become spent. So there are some anomalies that are thrown up in the Rehabilitation of Offenders Act, and I just want to use this brief case study to kind of illustrate some of the kind of potential pitfalls, things for you to look out for when it comes to requesting information. So here in this scenario, we've got Mike applying for a business administration placement at a leisure centre. And in December 2017, he was convicted of downloading indecent images and received a 6-month prison sentence. Now, a 6-month prison sentence has a 2-year rehabilitation period. That means in total, it would take 2.5 years for Mike's conviction to become spent, after which point he would not be required to disclose this information to the college or to the leisure centre. So we've got Isabel, who is applying for the same placement. December 2016, she was convicted of failing to stop and report an accident. She received a fine of £100, licence would endorse with 5 points, and the circumstances where she was rushing to hospital, her dad to hospital, who was taken ill, she pulled out too quickly from a roundabout, got involved in a minor accident. Now, for motoring convictions, the disclosure period is 5 years. So using this scenario, if we do the calculation, Mike's conviction would have become spent in May 2020. 2.5 years from the date of his conviction, whereas Isabel's conviction will not become spent until December of this year. So when it comes to applying to colleges or for placements, not those in sensitive environments, but the nature of placements of this nature that's provided in this study, only Isabel would be required to disclose her conviction. So you can see how it throws up these types of anomalies. It's unfair to Isabel, the fact that she was convicted a year prior to Mike, but is yet required to disclose her conviction for almost 1.5 years longer than Mike. And I suppose if I could put the question to you and you were able to respond, and I asked which of these convictions or which of these individuals would you be most concerned about, I suspect most of you would say Mike. There are exceptions to the ROA, to the Rehabilitation of Offenders Act, and that relates to DBS eligibility. So we've already kind of covered that a little bit previously, so we'll just get into that. So when we talk about DBS eligibility and college courses or university courses, what we're generally looking at is the second thing on the list here. So in order to qualify, in order for you to do a DBS check on your students at enhanced, standard enhanced or enhanced advanced level, and we'll get into the level shortly, they must be doing one of these things listed here at the top of the slide. So they must either be working in regulated activity with children or adults, work defined as work with adults or work with children, could be certain regulated professions, but in your instance, it wouldn't be the college that would be doing those checks, it would be the regulator. So that would be something that you may want to take into account at admission stage when information is declared to you, and whether or not that could create an issue for individuals who are looking to go into a profession. And that would be around managing their expectations. Because some of you may or may not be aware, but if you were to ask a regulator prior to the person applying to be admitted to a register, etc., for an indication as to whether or not a conviction or a caution would create an issue for that individual, they don't generally give you the right type of response or any helpful type of response that would help you to advise that person. So they would only find out at the stage of registering whether or not it would have an impact. Also as well, if they're doing placements in certain areas, in particular within the NHS, for example, then you would have to consider the impact of that conviction and whether or not the placement provider, such as the NHS, would have an issue with that. And then finally, there's certain types of licenses. Again, unless you're providing kind of security courses, it's probably not that relevant to you. But just in case you do, anybody who's looking to work in security is required to get what's called an SIA license, and the SIA are able to do or require that the person undergoes a DBS check, and that can impact their ability to go into that particular type of job. If you've got any queries around eligibility, then you can access a DBS tool online. The NHS also have their own tool, and you can also contact Nacro's Employer Advice Service. So we have a confidential service that is available Monday to Friday, 9 till 5. You can contact that service if you have any queries around eligibility or DBS checks. Some of you may have in the past or may contact the DBS customer services for this kind of support, but what they do is we have an agreement with the DBS where all of those types of queries are sent to our Employer Advice Service. So that is a service that's available to you all should you have any need for support or any advice around DBS checking. So when we come to the exceptions, the DBS have basically split up the types of roles into kind of 3 different parts really. The first one is the children's workforce, the second one is the adults workforce, and the final one is other workforce. And within each of those workforces, you are able to conduct 3 different levels of DBS check, which is the standard, enhanced, and enhanced and barred. So for the highest level of check, what you would need to demonstrate is that the person is engaging in regulated activity. Regulated activity with children here is defined as carrying out a specified activity, which is teaching, training, instructing, supervising, caring for unsupervised, or providing advice on well-being or driving a vehicle only for children, or it's working in what's called a specified establishment, part 1. And if the person is working within the specified establishment, within the normal course of their duties, there is the opportunity for them to have contact with children. And here you can see an example of some of the specified establishments. So we've got schools, pupil referral units, children's home, childcare premises. This does not include supervised work carried out by volunteers. So when we talk about students going on placements, because they are doing it in a voluntary capacity, they're not being paid for it, and they are being supervised, then they wouldn't be classed as working in regulated activity with children. But what they may be classed as doing is work with children, and we're going to look at that very shortly. The other things that could also be classed as regulated activity with children is any kind of relevant personal care provided to children, foster caring or registered childminding, or anyone who's managing somebody in that particular type of activity. So this is where the level of check I suspect your students who are going on to placements in kind of sensitive environments would be checked, which is the enhanced without barred list check. And that can be conducted for work that would be regulated activity, but done infrequently. So some of the activities that I mentioned on the previous slide, if they are not conducted at least once per week, or at least 3 times in a 30-day period, then it's not classed as regulated activity, but it's classed as work with children. Work that would be regulated activity if it was unsupervised. So yes, your students might be engaging in some of those activities that was on the previous slide, but because they are supervised, they would therefore be classed as working with children, and you would be doing this level of check. Applying to work in an FE college, when work brings you into contact with under 18s or a 16 to 19 academy. Now, work with adults, there's 3 questions that needs to be asked. Who are the adults? So who is the person working with? Is the job holder working with adults receiving any of the services listed? What is it they're doing? Are they providing a relevant activity to those adults? And how often are they doing it? Are they doing it often enough? So who are the adults? We have a person aged 18 or over who, and there's a list of things here. So living in residential accommodations such as a care home. So if we have students that are doing any kind of health or social care kind of courses and doing placements in care homes, they would be considered working with adults. Lived in sheltered housing, is receiving any form of health care, is receiving domiciliary care in their own home, is detained in lawful custody, is under the supervision of probation services, or is receiving a specified welfare service for the supply, assistance or advice for any purpose which has developed the individual's capacity to live independently in accommodation or support their capacity to do so. So these are the adults we're talking about. So anybody who falls within those categories is considered an adult at risk. And when we talk about the activities then, so we know who the adults at risk are, and the type of activities we're talking about is any form of care or supervision, any form of treatment or therapy, teaching, training, instruction, by assistance, advice or guidance, wholly or mainly for adults in receipt of health or social care service, moderating a public electronic interactive communication service likely to be used by adults, any form of work carried out in a care home, with the opportunity for contact with residents, representation of or advocacy service for adults with social care services, the conveying of an adult who receives a health or social care service, whether or not accompanied by a carer, and day-to-day management of all of the above as well. So what I would say based on the slides that we've just looked at is that, well, the majority, if not all, students who are going on placements would either be classed as being in work with children or work with adults, or both potentially, depending on the course they're doing. So what's important is how you gather criminal record information, any information that you gather. If you remember at the outset, I mentioned that there are two forms of disclosure, which is self-disclosure and verification. So now we're going to look at the self-disclosure aspect. And we're going to do that by looking at this case study. So you are a member of the admissions team at Long Lane College. We have Amy Thompson. She's applied to study on the health and social care degree. She meets the criteria in terms of skills and experience. And she recently obtained a level 3 NVQ in health and social care. But Amy has a caution for actual bodily harm. So for anyone who's unfamiliar with the terms that I've just used, a caution is where the police or the CPS, Crown Prosecution Service, have decided that there is sufficient evidence to prove the case, to prove the allegation, and or the person has made an admission of guilt, but they feel that it's not in the public interest to prosecute, and it would be best to give the person a caution. So this is a formal record that's created on the police national computer, and actual bodily harm is an offence against the person. And in terms of the scale of harm, it sits somewhere in the middle. So right at the bottom, you've got common assault. Following that, you've got battery. Then after that, you have what's called actual bodily harm. And then you get into the more serious offences such as grievous bodily harm and so on and so forth. So she has a caution for actual bodily harm. So what should we be doing in terms of gathering data? What we recommend is there should be some form of policy statement, just to reassure anyone applying to the course in terms of how the information they disclose will be dealt with. So what we would recommend is that you have a form of some sort where you're gathering this data, and included on that particular form, you should have a similar policy statement. And what we say is, we recognise the contribution that people with criminal records can make as students and welcome applications from them. A person's criminal record will not in itself debar that person from being admitted onto a course. Any information given will be treated in the strictest confidence. Suitable applicants will not be refused a place on their chosen course because of offences which are not relevant to, and do not place them at or make them a risk in the course for which they are applying. So what you're basically doing is you're saying to the individual, we're going to treat you fairly. What that does is it encourages that person to be open and honest with you in terms of disclosing what they should be disclosing, because they know that they're going to be treated fairly once they make that disclosure to you. Then you need to explain, how are we going to deal with this information? So what we have here is some factors that we recommend you take into account when doing a risk assessment. So we will look at these in detail as we move on. But what you should be saying, or what we would recommend you should say on that particular form, is that all cases are examined on an individual basis. And these are the factors we're going to take into account when we look at this information. Whether the conviction is relevant to the course applied for, the seriousness of any offence revealed, your age at the time of the offence and the length of time since the offence occurred, whether there's a pattern of offending, the circumstances surrounding the offence and the explanation provided, and whether their circumstances have changed since the offending behaviour. So you're just basically setting out, we're going to treat the data, we're going to treat you fairly when we get this data, and this is how we're going to use it. In terms of the question that we would recommend you ask, for the majority of your courses, so those that do not involve a DBS check, if you are asking people to declare criminal records, this is the question we would recommend. This question is legally compliant, so there's no issue with you asking people to over-disclose information and therefore putting yourself in difficulty when it comes to data protection. So you're not asking people to over-disclose. And the question is, do you have any unspent conditional cautions or convictions? Now at the bottom here, you can see if you were to verify, you could get what's called a basic DBS check. Most colleges and universities that I work with tend not to do that just because of the cost available. The costs associated with doing those checks. So you'll probably just be restricted to asking a question. And this is the question we would recommend. So any course, therefore, that requires a DBS check, so we're talking about health and social care, teaching, etc. This is the question we would recommend that you ask. So it's in two parts. First question is, as we had on the previous slide, do you have any unspent conditional cautions or convictions? The second follow-up question, because you are also entitled to take into account spent information for a certain period of time as well. You would ask, do you have any spent convictions or adult cautions which are unprotected in line with current guidance? So we're going to talk about what the term protected means when it comes to spent convictions and cautions. And there you see at the bottom there, you can then, after that, do your verification by doing one of these checks. Now, I will say that we do have templates of these criminal record declarations that if anyone would like, we can provide to you, which contains these particular questions and also the earlier policy statement and the statement setting out the factors you take into account. So they are available. If anyone would like a copy of that, that can be provided to you. So then we look at Amy's criminal record declaration, and we can see here the two questions as we've suggested. And the first question, she's responded no. The second question, she said yes, and she's disclosed a conviction for actual bodily harm, ABH 2017. So what's best practice when it comes to self-declaration? Review your policies and procedures, make sure they are fair to all candidates, and minimize risks of discrimination. Make sure you gather your criminal record details at the appropriate stage, and assess applicants on the basis of skills and experience first. Obtain declarations in an appropriate format. So the templates that I've referred to, once you have cited them, you'll see how they work in practice, and consistency as well. So what we would recommend is that you gather criminal record information from all applicants, whether they're based in the UK or overseas, and it's in a consistent format. So we next move on to verification. So how do we verify the information that a person has provided, an applicant has provided? Well, as I alluded to earlier on, because the level of DBS check you're likely to be doing would be the enhanced. So it's the, if we look at the enhanced column here, you see at the top there, it tells you, well, within these boxes, it tells you the information you would expect to see on an enhanced DBS certificate. So you would find out about unspent convictions. You would find out about spent convictions which are not filtered. We'll talk about filtering in a moment. And any cautions which are not filtered. But what you would also get in addition to that is police intelligence. Now, police intelligence relates to any information the police have access to that they believe is relevant to the course being applied to. And when we talk about police intelligence, or soft intelligence as it's also known, what this can be made up of is basically any kind of allegation that's been made against the person, whether that be a work-based allegation, an allegation made in respect of their study, an allegation that's been a criminal allegation that has either the police have taken no further action or they've appeared in court and been acquitted. So they've either been found not guilty or the case hasn't proceeded against them. All of that information can be shared. If there's been third-party agencies involved with that individual or their family, that information can be shared if it's relevant to the course. And it also extends to members of that person's household. So anybody living within their household or any kind of relation that is known to the police that, for example, if they are married or in a relationship with someone that's known to the police, and is intelligence relating to those third parties, the police can also include that information on that person's DBS certificate. The things you're unlikely to see in police intelligence on a certificate, only because the certificate goes directly to the applicant, not to your organisation. If, for example, a person is on the terrorism watch list, or they're currently being investigated or under investigation, and it's a covert operation, the person's unaware of the fact that they're under investigation, then that won't be disclosed on a certificate. You're more likely to receive a telephone call from somebody within the local police force to inform you of that. So moving on, we mentioned about DBS filtering. So there was a recent change that was in November 2020, where these rules were basically broadened. So prior to November 2020, the situation was, when it came to DBS certificates, if 11 years had elapsed since the person was convicted, or 5.5 years if they were under 18 when convicted, they had a single conviction, so they only had the one conviction. That did not result in them receiving a custodial sentence, including a suspended sentence. And it's not on what's called the DBS list of specified offences. So that list includes all sexual offences, all serious violent offences, all offences against children, all offences against adults at risk, some serious drug offences. There's over 1,000 offences on that list. So if you want to know, if you want to have a look at that list, that is available on the DBS website. So provided it meets that criteria, it's not on that list, the person did not get a custodial sentence and the relevant time period has passed, what would happen is that information would become what's known as protected, and it would be removed from DBS certificates and would no longer be disclosed, and the person would not be required to disclose that information. Now, what happened in November 2020 is they removed the one conviction rule, which means that a person can now have any number of convictions, and provided the criteria is met, those convictions will be removed from a DBS certificate. Why is this relevant? Well, it might be a case that somebody starts a course, and it might be a course where actually it's not determined what type of environment they will be working in until they apply for their placement. So I'm thinking along the lines of courses that may be, for example, sports related, where it's only in that person's second year that they decide, actually, I want to coach children, where they would then be required to do DBS. In the period between them applying for a course and you doing the DBS, their conviction might have become protected. And therefore, when you go to verify, the information may not be on the DBS, and that would be the reason why. The other reason why it's relevant is someone might declare something to you at the outset for a course that at some stage will require a placement or will require registration. Now, at that point, when you're looking at that information, you might feel, oh, that might have an impact on their ability to undertake a placement or to get registered. But if they're close to the end of the time period, it might be that at the point they are going forward for a placement, or at the time that they are being registered, that information has become protected. So it would have no bearing on their ability to do a placement or become registered, because this rule applies across the board to everybody, including regulators. And the second part of this is adult cautions. So adult cautions, someone who receives a caution aged 18 or above, the time period is a lot shorter than convictions, it's 6 years. And as long as it's not on that list, the same applies to cautions, so they would come off. Now, unfortunately for Amy, because her caution is for actual bodily harm, and that is one of those offences on the list, her caution would never be filtered, would never become protected. So it will forever be disclosed on her DBS certificate. You will note here, there's no mention of youth cautions. So prior to November 2020, youth cautions would have been disclosed on a DBS certificate. Now, youth cautions, final warnings and reprimands, as they used to be known historically, are no longer disclosed on any level of DBS check, which means that anybody, any students, anyone applying to your institutions who has received a caution whilst they were under the age of 18 are not required to notify you, declare that to you, nor will that come back on any level of check. So, and that has thrown up a couple of concerns, in particular where young people are getting cautions for offences that are of sexual nature, because they would be filtered. So, here's a copy of Amy's enhanced disclosure certificate. You will see there conviction for assault occasion of actual bodily harm, 2017 at Cardiff Magistrates Court, and she got what's called a youth rehabilitation order, which is like a community order that lasted 6 months. So how do we assess criminal record information? What are the types of things that we should be looking at when it comes to this type of information? Well, I mentioned it before, didn't I, about the factors that we should be looking at. So there's the nature and seriousness of the offence. There's the relevancy of the offence to the role or to the course. There's the length of time since the last offence. There's the pattern of offending, and there's the age at the time of the first and last offence. So most of this information, so the top 5 that I've just read out, you can find from sources such as the DBS certificate. So if I was just to take one step back, you can establish her age. So we know that she is she turns 19 in September. Or was my maths wrong? Actually, let's just work that out. She is currently 19. Yeah, I'll come up to 19. And we can see that her conviction was 2 years ago, so she was 17. So she was a minor when she was convicted. So when we go back to the slide where we look at the first 5 factors, well, given the nature and the seriousness of the offence, she got a 6-month, what's called youth rehabilitation order. And the youth rehabilitation order is essentially an order that's given as an alternative to custody. So it's where potentially somebody could be sent to prison, but the court's view is actually we feel that this should be dealt with in the community. So it's quite a high level of disposal. So that gives an indication of the potential seriousness of the offence. The next one is the relevancy. We know it's relevant because it's an offence against the person, and Amy has applied for a course where she will have access to, as part of her placement, vulnerable people. It's been 2 years since the last offence, so we know we can also gather that information from the DBS certificate. And there isn't a pattern of offending because it's a single offence. And we know that the age at the time of the offence was 17. So all of that information I've just kind of drawn out of that certificate. But the next kind of 5 factors, what we need to do really is have a conversation with the individual. And that's to understand the circumstances of the offence, the attitude to the offence, both then and now, and any efforts they've made to address past issues, not to reoffend, and make changes for the better, and any change in circumstances and responsibilities that they may have taken on. So all of that information we are gathering from the individual. So when it comes to risk assessment, again, we do have a risk assessment template. I'm happy to provide that to you. It's very detailed, but this is just an example of part of that form where we record, the risks that we've identified and the type of harm that may be caused as a result of those risks. So looking at Amy's disclosure, what we've identified as a potential area of risk is physical harm. We then look at who might be harmed as a result. So it's fellow students, because we have to take students into account, don't we? Because of the environment in which you'll be studying. Colleagues. So that's when she goes under placement, the people that she'll be working with, and the clients of that placement provider. So that's something that would need to be taken into account. What can be done to minimize that risk? Well, we can look within our own organization to see what safeguarding policies, what safeguarding practices do we have in place? Or we can look within the placement providers organization and see what do they have in place already to kind of mitigate against this potential harm. And what we have is training, we have supervision, there'll be a code of conduct, there'll be some form of whistleblowing, and if the person is left alone, there'll be some kind of loan working procedures as well. So those are the types of things that we can look at and say, we've already got these safeguards in place, we can take confidence from that. Now, the next 5 boxes along, we're going to look at a different slide to take into account likelihood, impact, risk level, further action, and need. Actually, it's not all of those factors, but just a couple of those we'll look at on the next slide. And then another nature of risk identified is potential reputational risk. And who might be harmed with the college and placement provider. So it's in relation to how would our clients, so how would the placement provider's clients react if they were to find out about Amy's conviction? What impact would that have on the college if fellow students found out, and parents of students, etc., etc. Those are the types of things when we talk about reputational risk. Now, in terms of the nature of Amy's conviction, it should only be shared on a need-to-know basis. So only those that Amy, that will be working with Amy, so we're talking about maybe the admissions team, maybe the head of the department, maybe the dean or whoever is involved in her admission into the college and those that are involved in the placement, they are the only people really that should be aware of this information. Now, there are circumstances where information like this could be in the public domain. So we could be talking about mainstream media, social media, etc. And that throws up a different set of challenges in terms of how you manage that data. And also when we talk about managing data, we're not just looking at protecting fellow students, clients, etc., but we're also talking about protecting the individual as well. So those are the risks that have been identified in respect of Amy. Now, what we have here is the traffic light system. So this is used to assess risk. The left-hand column, we have the likelihood of Amy reoffending. So what's the likelihood if Amy is put on this course, if she goes on this placement, what is the likelihood of her reoffending? And across the top, horizontally, you will see it runs from severe impact to very low impact. So what would be the impact should Amy reoffend whilst on her course or on the placement? So the red zone is high level risk. The yellow zone is considered medium risk and the green zone is considered low level risk. So the way it would work is, for example, if I was of the view that it was unlikely that Amy would reoffend, so that's the penultimate box towards the bottom there, second from bottom. And if she did reoffend. So if she did assault somebody, I was of the view, given the sensitive nature of the placement, that it would have a high impact, then I would land on 8. So that would mean I would consider that a medium risk. And then I would need to look at that and say, what have we got in place to mitigate that particular risk? And also to support Amy. When it comes to sources of information, so how do we get information? What we recommend is when the person is completing their criminal record declaration, that you ask them to also provide a supplementary statement. We call it a disclosure statement. And what's contained within that statement is obviously details of their offending, but also any of the connected circumstances. So the types of things that led them to commit the offences, and also to invite them to tell you about any support systems they have in place, and any kind of steps they've taken to address their previous behaviour. What I would say is you will see when you receive the templates that Nacro is heavily signposted within those documents. So anyone using them is able to contact Nacro, or you can signpost individuals to Nacro. We have a criminal record support service. It's free of charge, it's confidential, and students can get advice and guidance from our advisors around how to put together that type of statement. So please, if you feel that would be beneficial to your applicants or existing students who are facing allegations, then please do feel free to refer them to that service. So other relevant information that you can obtain information from the police, from probation, social services, the LADO, referees if you need references, if they've been employed from previous employer, if they've been involved with specialist services like drug or alcohol, anger management, sex offender treatment, or counselling or health services. You can approach those organisations, obviously with the consent of the individual, to obtain any kind of supplementary information to feed into your risk assessment. So my time is going off, which means that I'm almost coming to the end. I think I just have one more slide before I finish, which is how do you do an informed risk assessment? Well, there's 3 sources of information you should be gathering. That's information about the individual from external sources. So that would be the previous slide I've mentioned, all your DBS checks. Information from the individual themselves, and information about, well, it says job here, but it would be the course or working environment if they're going on to a placement. Put all that information together, that feeds into your risk assessment. So that's enough from me, I think. I think we're going to be taking some questions. I mentioned the employer advice service. I think that the templates I mentioned will be circulated to you all, but if you do need to get in contact, you've got my email here and the contact number for the service should you need any further support.
That's great, Chris, thanks so much. I think it's safe to say that the topic in the area is super complex and super nuanced. And I know from some of the questions that are coming through, people have certainly got queries around some of the bits that you've mentioned, just in terms of gaining clarity. Just to follow through with what I said at the beginning of the webinar, we won't get a chance to go through all of the questions in the 10 minutes that we've got remaining, but we will submit them to Chris and get written responses. And just to save Chris receiving 77 emails from NAM's members, if you're asking for the policy statements, the templates, all the slides, all the recording, we will share them on the network after today's event. So please don't fill up Chris's inbox with that. But of course, if you've got specific questions or training requirements, then do by all means contact Chris. I'm going to go straight into the first question, if that's okay, Chris, which is from Heather Hunt. So Heather is saying, how does the ROI, particularly on spent convictions, impact the applicant where they are attending a college where there are under 18s? So the applicant is attending college with under 18s, they're not working with them, but they are in regular contact.
Well, what the situation would be that information couldn't be taken into account, so they wouldn't be required to disclose that to the college, even if the college has under 18s, if they're a student. However, if their conviction is of a nature that is sexual, and they're either on the sex offenders register, so they have notification requirements, or they're being managed in the community, or they're subject to a particular type of order called a sexual harm prevention order, then even though their conviction might be spent, not in the case of the sexual harm prevention order, but it might be spent if they're on the register, for example, then the person that is, or the team that are managing them in the community, will make a decision around whether or not that information should be shared with the college. But other types of offences that are not necessarily related to safeguarding, the college would have to treat that person as though they were never convicted, and that information would not be disclosed to the college.
That's great. There's a question from Carol, which relates to an earlier part of your presentation, Chris, which is around verification. So Carol's asking, is it only adult cautions and not youth cautions that count for verification?
Yes, that's correct. So youth cautions are no longer disclosed at any level of check, and a young person and a person will not be required now to disclose youth cautions also. Just because in November 2020 the rules changed, so cautions are spent immediately. So if they're applying for a course that does not involve a placement and DBS check, they wouldn't be required to declare it. And those that do require a check, because of that rule change, the same applies. They would not be required to declare it. Now, there is one thing, and that's, I mentioned earlier about if someone has a caution for a sexual offence, which is relevant to the course, because the level of check that the college would be doing would be the enhanced check, and the police have the ability to share relevant information. Even if the caution is protected, i.e. isn't automatically disclosed on a DBS, the police can still disclose a protected caution and the information behind it on an enhanced certificate as soft intelligence if it's relevant to the course. So that's kind of like a bit of a safety net, safeguard that's built into the whole process.
So to go back to my previous comment, it's super complex and nuanced. So I think the slides will certainly be helpful in terms of referencing back some of the bits that you've covered off today. Mm-hmm. So the next question, Chris, is if an adult was sentenced for 4 years and that ended in 2015, however, it was of a violent nature, would that person's offence be protected after 11 years or never? And part of their placement at college would be working with children and young people.
Anyone who's received a custodial sentence, their conviction cannot be filtered. So that would always be disclosed in their DBS. So just to bear that in mind, irrespective of the length of the sentence, if they receive any kind of custodial sentence, it will always appear in their DBS certificate.
Great. A question from Sam Yates. When asking about convictions at application, is it appropriate to ask about ongoing investigations that they may be involved?
The short answer to that is yes. You can ask about pending prosecutions and ongoing investigations. Yeah, definitely.
Great. A question from Stephen, which is quite a specific one here. What about a person who has downloaded indecent images? They're not on a course working with children or vulnerable adults, but their record is unprotected and they have disclosed it to us. How would we know if there is a likelihood of them reoffending in terms of managing risk?
If they've got a conviction for downloading indecent images, then it might be, and it's unspent, then they will be managed in the community. So you will note on one of the slides I said you can contact either the police or probation. So you could get information from them about the potential risk factors. And the other thing to bear in mind is obviously we live in a digital world, so there might be restrictions in terms of their access. You know, how can they complete a course if they're not able to access computers or own computers, or there is a requirement on the college to have some kind of software that will prevent them from accessing certain sites, etc., etc. So all of that would need to be taken into account as part of the risk assessment. Those are the types of things that I would be looking at if there are no under 18s on the campus, for example. then it would more the more practical things I'd be looking at, such as their ability to complete the course, their ability to access electronic devices and those types of things. And I would be speaking to their probation officer or the public protection officer within the police force around any particular restrictions and any complications they may experience if they were to study on the course.
That's great. Thanks, Chris. Another question. If a student has a conviction and is due to go out on work experience, do we need to disclose this to the employer, their conviction, as I assume this breaks GDPR guidelines, in addition, limited information shared about this person due to bias? Or do we just tell them that if there's any problems with the student, just to get in contact with the college?
That is dependent on the arrangement you have with that employer. So the ideal arrangement would be that the college does the check, and if there is a positive disclosure, one of two things can happen. Either the employer says, right, so it's up to the college to do that risk assessment to make sure that person is suitable. Or the second option would be for the employer to be involved in that process. So similar to if, for example, when it comes to like NHS kind of placements, you know, most colleges would have a panel, for example, where it's a representative from the NHS and someone from the college would make a decision around suitability where there's a positive disclosure. You could have a similar setup with other employers. Now, depending on how many employees you have, that might be quite labour intensive. And if that's the case, then you need to speak to the employer and say what arrangement would suit you best. That you that you take part in any decision making, or that you entrust the college to do that. And what we can do is provide you with details of the process that we will go through when we're assessing suitability. But because of GDPR, we can't actually disclose to you the actual detail of what we're doing, but we can tell you about the process that we follow. That I think is, I can't think of any other kind of arrangements that would be suitable. So it's one of those options that I've mentioned.
Great. I think this is probably going to be the last question that I'm going to be able to ask, but as I've said before, Chris, I'll forward these to you and we'll get a Q&A into a single document for people. But I think this probably relates to some of the changes back in November 2020. So someone's asking, presumably we're still able to ask all applicants, regardless of their chosen course, about cautions or convictions, as we will always have to consider vulnerable students that they may be in college with.
So no, you're not able to ask all students to disclose all cautions and convictions. Students that are applying for a course that doesn't involve a DBS check, legally you cannot ask them to disclose cautions. So there's no legal obligation for them to disclose, and you could only ask those students to disclose unspent convictions, not all convictions. And it's very important that you do that, because if you're asking students to disclose everything, then essentially what you're doing is you're breaching data protection. And that student, if the decision is that they're not suitable for the course, could have a cause of action against the college, and they would most likely win, because that would be breaking the law. And when it comes to those courses involving DBS checks, then I would recommend you use the questions that I suggested, because they're legally compliant. Because again, you're not entitled to know about any youth cautions, and the only convictions you are entitled to know about are the ones that are not protected. So if you're asking them to disclose everything and they happen to disclose something that is protected, and that's taken into account when assessing suitability, again, the point I made about data protection would apply. And also remember that the questions, the questions, the way they're set out, and in particular the question for courses involving a DBS check, that applies equally to regulators. So even a regulator, even for example the NMC or the SRA if it's law, or the GMC for doctors, they cannot take into account protected convictions and cautions. They cannot take into account any cautions given to somebody in their youth as well. So the rules apply to them, and therefore, you know, it would apply equally to the college.
Chris, that's great. We are bang on 1 o'clock, so we're going to have to wrap it up. There are 10 questions unanswered, but we will absolutely go through them and make sure that all attendees receive those, along with the policy statement, the templates, the slides, and the recording. Chris, you've been fantastic. Thanks so much for navigating us through something which is so complex. There are loads of questions that people have asked, and we'll come back with some great comments and feedback also within the chat that you can have a read through as well. So thanks so much for joining us this afternoon. Thank you to all of the members that have tuned in and taken the time to listen as well. We'll share all of this information with you in due course, but thank you again for joining us this afternoon.